The president's turn to the judicial system is not slowing the challenges for the Jeffrey Epstein story that have been created for him inside Congress. There's a bipartisan push underway right now to demand the release of all the Jeffrey Epstein files that is underway in the House. So far, it's got 10 Republican co-sponsors that include some of the president's most vocal supporters, as you can see here. Republican Congressman Thomas Massie tweeted, "Folks, keep the pressure on. It's working, but we want all the files."
So here's what's going on. The president is putting pressure on the court system, but that isn't stopping the heat he's getting from all the ongoing Jeffrey Epstein issues in Congress. There's an effort happening right now with members from both parties pushing to get access to all the Epstein files. It's picking up speed in the House and has the support of 10 Republican co-sponsors, including some pretty strong backers of the president. It's interesting to see Congressman Thomas Massie firing people up on Twitter, telling them to keep up the pressure, saying it's really starting to work, but they want all the files.
California Congressman Ro Khanna, and it's great to have you here, sir. I wonder, when it comes to what the White House is pushing for now, after facing so much pressure to release parts of the grand jury testimony that can be released, do you think that's a good start?
It is a good step. And they obviously are responding to what Thomas Massie and I are doing in Congress and the fact that there are 10 Republican co-sponsors.
Now, on the lawmaking side, the lead Democrat involved is Congressman Ro Khanna from California, who's pretty open about the need for this information. When you think about what the White House is trying to do under all this pressure to release parts of that grand jury testimony, you can't help but wonder if it's a good start. Khanna believes it is indeed a positive step. He mentions that they're responding to the work that he and Massie are doing, especially with those Republican co-sponsors in play. However, the tricky part here is that most of those grand jury evidence files are tied directly to Epstein.
The problem is, Caitlin, that most of those grand jury evidence files are concern Epstein and Maxwell. They aren't concerning all of the rich and powerful men who may have engaged in illegal conduct. And the second problem is that is subject to a court's order, whereas there's a lot that the Justice Department has in terms of interview memorandum, in terms of texts and emails that is in their own discretion to release, and they can do that while protecting the victim.
And then there's the March 5th Supreme Court ruling that a lot of media outlets have really got wrong. It's surprising just how off they've been about the most important part of that ruling, which could pose a real threat to Donald Trump right now. The court made it clear that no one is fully protected when it comes to being looked into for actions related to Epstein, even if that person later becomes president. They looked at everything that allegedly happened between Trump and Epstein before he took office, particularly during the period from 2002 to 2004.
When it comes to what the push is for on Capitol Hill, with the number of co-sponsors that you have, can't you force a vote come September?
We can. In fact, we could have probably forced it earlier, and the speaker is well aware of this, and that's why I think he's going to adjourn us early next week, because they don't want the 7 days to take place. Massie and I introduced the bill. It has to sit there for 7 days before we can have the discharge petition.
This includes call records and documents from Mar-a-Lago, as well as a series of links and communications that have been hidden away in those 53 pages that NPR looked into back in February, which revealed serious assault claims. The court determined that none of this information is protected under presidential privilege or any immunity claim recognized in American law. Now, federal prosecutors have access to all of it. All right, let me catch you up. So the House Oversight Committee has made an interesting move by ordering Attorney General Pam Bondi to testify about how the Department of Justice has been handling those Epstein files.
Domestically now, we've seen lawmakers late today vote to subpoena the Attorney General for the way her department has handled the Jeffrey Epstein investigation. You saw a handful of Republicans, right, so people in the president's own party, joining Democrats on the House Oversight Committee to vote to bring Pam Bondi in, including Nancy Mace, the congresswoman on the Republican side. Watch this.
I have a lot more questions, and I don't expect to be talking about the stock market. So she better not bring those notes when she comes to the Oversight Committee.
Just a little under 2 weeks ago, they voted on this in a pretty surprising twist with 24 members in favor and just 9 against it. Some Republican members even joined with the Democrats on this vote, which says a lot about the concerns building around the release of those files. Now, here's where things got really significant. The Supreme Court just ruled together with every justice agreeing that a president can't protect themselves from being held responsible for alleged actions taken before taking office.
Courts have ruled that U.S. presidents are immune in civil cases for what they did in office, meaning they can't be sued. But can they be charged with a crime? That's a question that has never been tested. Now, an appellate court has weighed in and decided unanimously former President Donald Trump is not immune.
That's right. Not even the three justices picked by Trump had any disagreement on this matter. So now this ruling opens the door for the House Oversight Order, allowing them to dig into Trump's call logs from 2002 to 2004 related to Epstein, along with all those documents from Mar-a-Lago that the DOJ has kept hidden. This order is serious business, and there's no legal protection left for Trump to rely on. And how did Trump react? Well, he went on quite a posting spree on Truth Social, putting out a total of 27 posts in a single day, claiming it's all a witch hunt and that he's going to expose everyone involved.
Several different stories and angles on this prospect today, including one with this remarkable lead. Reading from the Times, quote, Donald J. Trump claims he's ready for his perp walk. It draws on accounts that Trump is telling people he welcomes the idea of being paraded for any perp walk and is mulling whether he should smile, I should say, in his...
It's honestly hard to believe he said that out loud. So it looks like things just took a pretty wild turn for the former president. The Supreme Court just all agreed against his claim for protection. And get this, all 9 justices, including the 3 he picked himself, were part of this ruling. Can you imagine the President of the United States calling these justices traitors? That's definitely a strong reaction, especially considering this has never really happened before in American history when it comes to a president dealing with a court decision that didn't go their way. He had a bit of a meltdown online posting about these justices being traitors. And with that, he's framing this ruling as a total disaster for his presidency. It's significant because the legal plan that his administration has been leaning on throughout the Epstein blocking situation relied on one big idea, that the presidency would keep him safe from being held responsible, not just for things happening during his presidency, but also for stuff that happened before he even took office. Well, that idea just got shut down by all judges, mind you, by the highest court. So now the protection he thought he had is gone, meaning actions he took before he was president are now completely open. They can even demand call logs from 2002 to 2004, along with the documents from Mar-a-Lago. Those pages that have claims of assault, which were or can now be accessed by investigators without any protection blocking their way. And legal experts are saying that because of this ruling, Trump's going to have to speak under oath in the Epstein investigation. It's no longer a question of whether it might happen, it's become a set process. There's even talk that a formal charge for blocking justice against a sitting president is shifting from being just a thought to something that could actually happen. Given that he's sitting at a 28% approval rating, and with 45% of Republicans going against his leadership, the environment surrounding all of this legal trouble is pretty tough right now. Probably the most challenging it has been during his whole time in office. Today, I'm diving into everything related to this situation. The legal ground for the ruling, why the exposure of actions before presidency is scarier than the protection of a sitting president, what the orders from the March 5th decision are targeting, the fallout from his meltdown, and what could come next. Stick around. We've got a lot to cover. Let's dive into why this recent ruling is such a big deal, especially from a legal standpoint. It's actually pretty interesting how the court's decision shakes up the previous understanding of presidential protection. At first glance, it might just seem like another court ruling, but there's a lot more to it that is pretty significant. Once you understand the legal structure behind it, you start to see why a reaction like calling the justices traitors isn't all that surprising coming from someone processing what this ruling truly opens up. So, let's break down the legal question that the court tackled, which is where a lot of the media coverage has got it wrong. Most of the talk around protection has revolved around whether a sitting president can keep their administration's actions covered up. We've been hearing about executive privilege and how it involves Department of Justice communications, plus the protection arguments regarding decisions made by the Attorney General and the FBI Director regarding documents they can share or keep hidden. Those discussions mainly look at the actions of a sitting president right now. However, this ruling goes a step further and addresses a different issue, whether someone can become president and then go back and protect themselves from being held responsible for things they did as a regular citizen before taking office. The court has made it clear absolutely not. Regular citizens don't get a free pass just because they later become president. What does this mean for Trump? Well, it opens up the entirety of his life and actions before he took office to investigators looking into the Epstein case. That includes call records from 2002 to 2004 that supposedly show direct links between him and Epstein during the time when Epstein was committing his crimes. It also brings into play the documents from Mar-a-Lago that detail an Epstein ban, which has always been a bit of a mystery, plus all those pages that were previously kept hidden, which include assault claims against Trump from before his presidency, are now fully accessible without any protection covering them. It's honestly hard to believe he said that out loud. The Supreme Court has made it clear that all records from the time of Epstein's crimes are now open for investigation. This means every call log, document, and piece of evidence is reachable, especially concerning what happened and who knew about it while those crimes took place. The recent House oversight order, pushed by a decision made on March 5th, specifically targets this material. Understanding what this order means is key to realizing why this new ruling poses a much bigger challenge for Trump compared to previous legal issues he's faced. It's not just any order, it's focused on Trump's records from before he became president. Things like call logs during the time Epstein's operations were going on and papers from Mar-a-Lago that supposedly show Trump's direct contact with Epstein during that period are now in the spotlight. We're talking about evidence concerning numerous assault claims that the administration has been trying to keep hidden. Now, when looking at the situation with Bondi and Patel in light of this ruling, it gets even more interesting. There's this legal loop where the rejection of pre-presidential protection ties back to their ongoing document hiding. Both Bondi and Patel are facing tight deadlines regarding being held in contempt. The documents they've been holding back include those records from before presidency that are now exposed because of the protection ruling, along with their communications from after Trump took office concerning how to handle the hiding of that very material. Now, with both types of documents becoming available thanks to this ruling and the ongoing federal investigations, the administration finds itself in a tough spot, having to decide whether to release information that could shed light on events before Trump's presidency, all while dealing with the fallout of those previous decisions. It's quite a turn of events, isn't it? The Supreme Court just made a full decision that took away the legal protection we used to see this administration lean on, and now things are really heating up. The materials that were once covered, including those 53 held back pages containing serious assault claims, are now fully open to investigators. It looks like the clock is ticking on the Bondi contempt deadline, with blocking charges actively being pursued. In just one day, there were 27 posts from the president, and the approval rating is sitting at a poor 28%, with 45% of Republicans going against him. With those legal and political shields gone, the information that was being guarded is rushing towards investigators and congressional orders faster than this administration knows how to handle. The big question hanging over all of this has always been the same. What exactly is in those 53 pages? What went on between the years 2002 and 2004? And what does the paperwork from Mar-a-Lago really show? Whatever the answers are, they're turning into serious political outcomes, with threats of federal jail against the Attorney General and the backdrop of a ruling that some are calling a hidden takeover from the deep state. Now, federal investigators have the go-ahead to find out what's actually going on. And as we head toward the contempt deadline on the 20th of March, we're looking at a key time in the legal and political landscape of the country. The pre-presidential protection is gone. Orders are being issued, and those sensitive, potentially damaging materials are set to make their way into the spotlight. This information is likely to land in a political setting that's already buzzing at that low approval rating and climbing gas prices, $55 per gallon with just a 5-seat margin separating this president from another impeachment.